The fourth speaker is Isabel Turégano. Turégano. She is a senior lecturer of philosophy of law at the University of Castilla-La Mancha. Okay.
Correct.
She come to talk to us about privacy as data protection, some critical legal problems. You.
Okay, thank you very much. Well, I'm presenting here a paper which is a collective contribution of a project in digital age, new problems for the law, and we are studying some impacts of technology, information technology on legal systems. And here we present some critical problems we have studied in that with the other members. We are studying the gathering of information by financial institutions. We are studying also the problem of standards of evidence from information technology and the international legal approach, which demands some answers from international private law. And first of all, we have seen that the first problem is clarify the concept of privacy. Because when we talk about privacy, we are talking about such different things that sometimes we are not sure what we are talking about. And the concept we propose here is a very broad concept which takes into account quite different things. One has to do with intimacy, and the other has to do with control, with power, and these are very different things. So sometimes when we talk about privacy, we are talking about intimacy or something related to intimacy. Garzón Valdez made a very important distinction between intimacy, private, and public. We have three different areas or spaces. Intimacy has to do with autonomy. Intimacy is the last redoubt of personality. It's the inner side of our lives that should develop outside the public exposition, because it has to do with the operation of personal feelings, fantasies, imagination, thought. Intimacy is irradiated in private areas where we make personal relationships depending on our preferences and our desires. So privacy from this point of view has to do also with autonomy. Privacy is that space where we make special relationships. So the information we share in these private spheres, in these private areas, it's of a special kind because it's in a context of caring, and we share information as a constituent element of the relation. In this sense, privacy, as I have said, has to do with autonomy. But the province of privacy is broader than intimacy. Privacy also has to do with data protection. And when we talk of a right to data protection, it's a different right of intimacy. Right of intimacy has more a negative aspect of exclusion, but right to data protection has more a positive aspect of control over personal information. And these two rights are quite different for various reasons. First of all, they are different because data protection has to do with information, with something that is tangible, something that can be collected, analyzed, processed, disseminated, and intimacy has a more ethereal nature. Second, the reasons why we want to protect data, personal information, is not only autonomy, it's also security. There are information-based harms. It's equality, because exchange of data for benefits take place in a fair. It doesn't take place in a fair and transparent context, and also because mining involves that people are categorized, and that means losses of opportunities, that means inequalities because some social stereotypes are formed, that means oversimplification of diversity, that means reduction of autonomy. Bauman, for example, says that categorizing people reduces autonomy through enticements and seduction without need of coercion. So privacy, the risks are, as I have said, security, equality, and also justice and control use of data beyond the purpose and context for which it was collected favors dominance of powerful institutions. So the menace, the risk we have in front of when data are not protected are completely different of the problems of intimacy or of lack of autonomy. It's a problem of a quite different nature. It's a problem of power, of control. And in this sense, privacy, self-management framework is not sufficient. It assumes the role of legislation is to give individuals the means, notice, access, consent, correction, by which they can protect their privacy. But this view does not take into consideration that, that privacy is a social value. Public regulation of privacy should help to move people away from irrationality or indifference when providing personal information, and it must protect the most vulnerable. Government constraints on individual choice are legitimate when it is exercised in is not legitimate when it is exercised in a non-transparent context. There is no real competition, and subjects are unaware or do not participate in the determination of purposes. Certainly, impeding information flows can have significant economic and social costs. Like any other value, privacy must be weighed with other values. This is the case of the two problems I have referred at the beginning. First, the problem in the environment of financial information, where privacy must be weighed with the prevention of market abuse. We are not witnessing the creation of a sort of financial memory of all the transactions that take place daily in investment firms and credit institutions. We have a European regulation, some directives from 14 and delegated regulation of the 2017 that obliges to the recording and storage of all the communications between the client and the institution, the credit institution, that must be stored in such a way that it allows the transactions to be completely reconstructed. The aim is to detect transactions involving market abuse, initiate the relevant investigation, and have evidence to enable the punishment of the subjects. For that purpose, the information will be available to the competent administrative authority. But the reality is that we have such a great base of data that it implies an enormous risk for various reasons. First of all, because it is regulated in a directive not completely transposed in every country, because also it affects quite important fundamental rights, and because it is designed in such general terms, it records the entire, or it implies the recording of the entire conversation indiscriminately, that it's strictly necessary to make some kind of differentiation, limitations, and exceptions. The other problem we have been studying in our project is the use of video recordings at workplace. If the key aspects of data protection lies in information and consent, what happens with recordings not expressly consented? For example, such recordings in ordinary monitoring activity with other purposes, for example, for security purposes, that capture illegal activities performed by a worker that fall outside the purpose of the recording, and this cannot be used as evidence. But it's something paradoxical that this cannot be used as evidence in labor proceedings, but it is used as evidence in criminal proceedings. So our proposal is, or our idea is that here is some kind of inconsistency, and maybe some of this evidence can be used in some, if we take into account some considerations. First of all, evidence just less than a minute. Some evidence is the evidence. It can be used with the evidence obtained in relations between private individuals, and not with a purpose to be used in a proceeding. And secondly, when evidence is obtained by chance or in good faith, in the sense that the purpose of the recording was not to obtain evidentiary sources for court proceedings. Well,
Okay.
thank you.
Thank you.